Welcome back, everyone. So, in part 2 of this third class, we are going to discuss some main principle of Takaful contract, starting with the permissible Takaful interest. So, we discussed that the interest here, the subject matter must be Takafulable. Then we will discuss the doctrine of utmost faith in which we enter in the contract. Then we will discuss indemnity. So how do we compensate? Subrogation, some new concepts maybe related to the insurance world, let's say. And then contribution, tabarro, we already discussed it. We will get more details about it. Then we will move to warranty. What is warranty? What are the types of warranty that we need to learn here? And then we will end with the proximate cause. So when something happens, sometimes there are many causes contributing. So what cause shall we compensate here for? Basically, the proximate one, the main one who caused the damage. Okay, let's move to permissible interest. So here there is basically a financial relationship between participant and subject matter covered. So there will be conditions here. Let's see. Benefit financially and economically. Let's continue. The condition: should the subject matter survive or remain in existence, or suffer financial economic loss should the subject matter be destroyed. So the subject matter here, a car, a house, a painting, anything, must be measurable. We need a benchmark to know the price. We need to basically determine the market value of this. How? Maybe by looking at the same car at the market, the same house at the market, etc. So let's get some more details. Number one, in case of ownership of some property, what can happen? Damage to the property. So property owners will lose financially if their property is damaged or destroyed. Can we measure this property value? This will be the condition. If yes, then we can start a product or create a product to do what we need to protect the participants against a specific risk. Number two, potential legal liability. Sometimes we are conducting business, suddenly we have some legal liabilities that might basically cost us so much money. So we want also to be protected against these risks. Potential financial loss arising from a legal liability. For example, employers have legal liability if the employee suffered a loss or some unfortunate event during work, fell from a ladder, got electric shock, etc. Any of these that can be disastrous sometimes. So the employee might sue the business owner, let's say because there is no means of protection, the environment of the workplace is not there, etc. Finally, contractual right. There is a provision in the contract whereby one party is financially responsible for any loss or damage or property to a third liability. This is very clear when we drive. Let's say we hit a car, and while we hit the car, we cause damage to a third and fourth and fifth party. We call it third party. Someone who's not really involved in the accident but suffered due to our accident, was passing by, got hit, suffered some maybe minor, major losses sometimes. So we also need to be protected against these things. So the principle of permissibility here, the first principle is that things which Allah, so what's the rule in Islam? What is permissible? How do I know? Shall I eat mango or apple? So the law in Islam is that Islam will only discuss what is impermissible, forbidden. Other than this, you can do whatever you want. So Allah didn't discuss what fruits to eat, right? So you can eat all fruits. We call it mubah, permissible, unless there is a clear prohibition in some of the Islamic sources of law. So nothing is haram, that's the rule. Nothing is haram except, you must continue the sentence, except what is prohibited by a sound and explicit nas. Nas means text that can be from Quran, Sunnah, or Ijma, or Qiyas, etc. Now let's move to the doctrine of utmost good faith. Parties enter in Takaful contract for what? We discussed that just now in the previous part. In utmost good faith means what? With very good intention, brotherhood, remember? We want to be brothers in arms here. We want to protect each other against theft, etc. Something. So, you must disclose all material facts. Of course, to enter into such contract, number one, we need you to be trustworthy. So do not lie and tell us, for example, the value of my house is 2 million, whereby it's 1 million, or the car is 1 million, whereby it's 10 million, etc. So no concealment or fraudulent misinterpretation. Material facts, information which will affect decision of both parties when entering into the contract. So sometimes I will ask parties questions, both must answer correctly, no lying. Why? Because I'm asking you questions that will be important. What's the value of this property? When did you buy it? Why is it not being rented, etc.? Many questions you must just answer without hiding anything. Info will influence decision of underwriter. So if your car value is 10,000, I would charge you different from 50,000. That's why you need to be honest whether to accept such risks. Sometimes the TO would say, we do not cover these risks. You need to find a new company. Okay? So if accept, then at what terms, conditions, and rates. So you negotiate the terms of the contract. Of course, the evidence on this utmost faith is easily found in the Quran, in Surah Al-Ma'idah 5:1, O ye who believe, fulfill all obligations. So if you have an obligation, which you have here in the Takaful contract, you must fulfill it. So the concept of amana now is also discussed in the Quran in Surah An-Nisa. Allah does not command you to render back your trusts to those to whom they are due. And when you judge between man and man, then you judge with justice. Verily, how excellent is the teaching which He give you, for Allah is He who hears and sees all things. So basically, this stresses on the relationship between us as participants and the TO. So the TO shall deal with us or treat all of us fairly, the same. Cannot charge me less because he knows me, cannot give me more claim because I'm his friend, etc. So there is the concept of amana here. They are basically working as our wakil, which basically works on the basis of amana. Now let's move to indemnity. So protection, compensation, or security against damage, loss, or security against legal. We discussed legal responsibility as well. So in case I face these unfortunate events, you must compensate me for the financial loss I suffered. So financial compensation to place participant back. So what shall Takaful operator do here? Put me back where I was before the unfortunate event happened. So, how do you put me back? Maybe replace it for me. Give me the money to buy a new one. Whatever the best way to accomplish that. So, it must not be better than before the loss. Once it's more than what you had before, it raises questions about gambling, right? Why did you gain from this? Remember when we discussed risk, we said this kind of risk is not speculative. You cannot gain. Must be a pure risk, either loss or no loss. If there is loss, I'll put you back to where you were before the loss, not better. I'm not gonna buy you a new nice home. I'm gonna buy you the same home. I'm gonna buy you the same car. Okay. So participant must prove he suffered a loss, evidence when the event happened, and loss must has monetary value, must be measured. Cannot say I lost, give me 2000, let me fix my car. Maximum benefit is the value covered or actual market value. Okay, so let's take an example. I go to buy insurance for my car and I tell them the value of my car is 50,000, whereby it is 40, but I was aiming that if I had an accident I get extra 10. However, the Takaful company will check the market price. If the market price is 40, they will only compensate you for 40 to get a new one in case of total damage. Okay, so even though you paid higher premium because you considered your car as 50, but because you lied or you didn't do the task properly, you will basically not be compensated for 50. So the company will always find the cheaper price. If the opposite, if you said it is 40, whereby the actual basically price, market price is 50 higher, you will not get 50 because you said 40 to pay less premium, right? Because premium is associated with the price of the value of the car. Okay, so the company will always pay the lower price. Okay, so at Takaful, participants subscribe in Fire Takaful for his house for a coverage of 2 million. Okay, knowing that the prevailing market value of the house is 1 million. So I bought a Takaful for 2 million. However, my house value is only 2 million. 6 months later, Fire, under the principle of indemnity, compensation will be equal or less than 1 million. Market value here is lower, so we follow market value. Irrespective of contribution, you cannot argue I used to pay more, so you cannot get any money back. Now let's move to subrogation. I'm not sure you heard the word before or you used it. It's well used in insurance and the Takaful business. So what's subrogation? The rights of TO having indemnified the participant to exercise the participant rights against any third party. Okay, so I hit a car. My company will pay the car, the damaged car person. However, why did I hit the car? I hit the car because someone hit me from behind. So I hit the one in front of me. So who's the proximate cause? We will get to that later. The one behind me. So now my company will first settle the payment, but later they will pursue my right to get money from the one who hit me from the back and compensate themselves because I wasn't the reason for the accident. So they will recover the amount they basically paid. For example, Mr. A here has a house, submitted a claim for 500k, half million ringgit for fire takaful. Now, upon payment of claim, TO has subrogation right to claim the 50 million from the factory. What's this factory? So why was my house on fire? Let's ask this question. The reason is there was an explosion in a nearby factory. So what's the cause here? The factory. So my company will pay me the money, but then will basically go after the factory to get the money, ultimately responsible. So who's ultimately responsible for the loss? The factory. Now let's move to contribution. Let's read this together. If at the time any claim arises under this certificate, there is any other insurance takaful covering the same loss. So, I purchased a car insurance from two companies. They didn't know. So I paid two premiums. Why? I thought to myself that I want higher protection. Okay, so let's see how it goes. There is any other insurance covering the same loss, destruction, or damage, takaful operator shall not be liable to pay or contribute more than their rateable proportion. Okay, so I had an accident. Can I go to company A, claim my money, and then go to company B, claim my money? No. Can I claim it all from A? No. Can I claim it all from B? No. I must claim it from both. How much each? Based on the rate. We will see in the next slide. So, rateable proportion, remember this word, must be based on the rate, okay, of any claim for such loss, destruction, or damage. Applicable in the following circumstances: two or more takaful certificates in force at the same time. They cover a common interest, so same takaful for car insurance. They cover a common peril against accident, same peril. The loss involves a common subject matter covered, same car. So let's see this example. So here I purchased two basically contracts, okay? We will see with this formula how do we compute the compensation. So example, some covered from TO1, 6,000. Some covered from TO2, 4,000. However, I had a minor accident. What was the loss? Not major, only 1,000. Again, can I claim it all from A? No. Can I claim it all from B? No. Can I claim it half-half? No. You must claim it based on rate. Loss 1,000. First, we determine the percentage ownership basically here, the rateable contribution. So how do we do that? As we can look, total is 10,000. So 4 to 10 is 40, 6 to 10 is 60. So 40% TO1, TOB, 60% TOA. So based on this, the 1,000 will be split accordingly. So based on ownership percentage, we multiply by the loss. And then we can come up to the result, 600 from TOA, higher percentage, 400 from B. Finally, proximate cause. What does proximate cause? I just said it in the previous example. We will take more examples. So proximate cause means the active, efficient cause that sets in motion a train of events. Again, something terrible happened. The consequence wasn't on one, but started with one. This one led to another, led to another, led to another. A train of events. But how did it start? From the proximate cause. We go back to the proximate cause. What was the main cause for death? Okay, we go back to the main, let's say cancer. But what was the proximate cause for the death? It's not cancer, it's maybe smoking who led to cancer, who led to death. So we will see clearer examples later, which brings about a result without the intervention of a force started and working actively from a new and independent source. Let's take a look at this example. A man fell from a horse and sustained injuries. So someone was driving a horse, then fell from the horse, sustained injuries that prevented him from moving. So he's paralyzed, cannot move anymore. As a result of being paralyzed, he contracted an illness called pneumonia. Okay? due to lying in the bed and not being able to move, and died because of this illness. It's a serious illness. So what's the proximate cause here? Why did you get paralyzed and had to stay in the bed and die from this illness? Because of the fall from the horse. So the proximate cause of his death was held to be the fall, not the illness. Let's take one more example. Okay, so in 1876, a fire damaged a wall. Fire started, damaged a wall, damaged the wall, okay, and weakened it. It became weaker. Several days later, a glebe, strong wind blew down the weakened wall. So very strong storm blew the whole wall. So it was held that the fire was not the proximate cause here. Okay. So seems to be whether the original peril was still operating and was the dominant cause of the loss. So sometimes it's not easy to judge. It goes to the court. The judge will take care of it, see the proximate cause. But here you need to understand that in Takaful, we will always follow the proximate cause. Okay, one more case. Lightning damaged a building, weakened a wall. So the lightning damaged a building and weakened a wall. Shortly afterwards, look at the word, shortly afterwards, the weakened wall was blown down by high winds. So it didn't happen the next day with a storm or the following day. So lightning was considered to be the proximate cause. Of course, lightning weakened it, maybe minutes or hours after. Strong wind, it fell. It's different here. It was held that the proximate cause here is basically the lightning. So in the first case, it was evidently felt that the wall was secure. So in the first case, the wall was secure, not gonna fall. Whereas in the second case, this was not so, and the gale operated before remedial action could be taken. So in case it's a company, Takaful company, so the Takaful company should have fixed it immediately, but because they didn't fix it immediately, it needed some remedy, so it fell from the wind. So again, what you need to understand here, not how to judge things, we're not going to be doing that. You need to understand that it will always be the proximate cause that we will consider. Let's move to warranty. You know warranty, right, when we buy something with a warranty. However, warranty has different types. So a warranty, you all know it, a usually written guarantee of the integrity of the product, how good it is, how it works, and because it's that good, we will give you warranty basically of the maker's responsibility for the repair or replacement of defective parts. Let's begin with affirmative warranty. What's affirmative? As the name says, affirmative warranty. It's a statement regarding a fact at the time the contract was made. So now we are contracting. I ask you, do you smoke? Say no. I put no. Do you eat well? Yes, I put yes. Do you exercise? Yes, I put yes. Later on, you smoke, you don't eat well, you never exercise. Okay? So here, the warranty, basically the takaful will not be there to help you because you lied about all of these things. So protection cannot be given if the participant already possesses certain diseases, for example. So I'm not going to investigate all of these diseases and run tests for you, which might cost me 5,000 ringgit. At the end of the day, if I do that, I would lose money more than your premiums. So I would ask you, you have to confirm that you don't have it. Now let's move to the other kind of warranty, promissory warranty, promissory. Okay, so it's a statement about the future facts that shall continue to be true throughout the period of coverage. So now you have to promise me some things and you would never do throughout the whole contract period. For example, If breach, TO may cancel coverage at the time. So if you started doing something I told you not to do and you signed not to do, I will cancel the contract. For example, fire takaful shall never be used for making explosive products. So if you are a factory and you are, doing some business, maybe I will give you insurance. However, once you start dealing with bombs or something that can explode, of course, fire takaful will be cancelled. So I must tell you these things up front as a TO. We call this promissory warranty. So if participants decide to start making explosive on the property, the coverage shall be cancelled. With this, we end this part here. Thank you very much for listening. I hope you enjoyed the class. Please don't forget to write down your notes and be ready for our Q&A session, inshallah. Thank you very much. Wassalamu alaikum wa rahmatullahi wa barakatuh.